Hello, everyone. Yo, come on in. Welcome. Welcome. Hello, Neil. How you doing, buddy? We're gonna have a lot of fun today. Welcome, welcome. What's going on, Edwin? What's going on, Cedric? How y'all doing? I'm doing great, Neil. If y'all can hear me, put a 1 in there. Let me know how the audio is. I haven't been on this microphone in quite a bit. Press 1 if you can hear me very clearly. Perfect, 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 perfect. So we're going to jump right into it. This is going to be one of those videos that may or may not make it to the general population. So a lot of my credit people, if you would, why don't you go ahead and share the video, let people know to jump on this information. We don't want to be stingy with it. We want to get it out to as many people as possible. So let's go ahead and share that. And of course, if you find the information helpful, definitely please participate in the super chat. And all right, thanks. What's up, Josh? So tonight I'm going to be teaching how to delete repo debt. So again, we want to get a few more people. Let's get at least 25 people in here, and then let's get started. I had to run in here from cleaning out the pool, I tell you. So I've been a little rushed. But let's get 5 more people in here and let's jump into this lesson. This lecture is going to show you how to eliminate a huge debt. And for those of you that end up helping others, it's going to show you how you can do this for other people. So share this with a few people, and then we're going to jump into it. Excellent, excellent. Let me open up another window. I like to visualize everything I'm doing. So I'm going to open up a Word window, and then we'll sort of I'll be taking notes for you. All right. And I don't use this a lot, so let's see. So we're going to open. All right, so I'm gonna show y'all. I'm gonna talk about some things here. Make it a little bit larger so you can see it. All right, so today I want to talk about how to delete repo debt. Well, first of all, I'm assuming you all are here because either you have a repossession debt or know someone that has one and you're a credit professional trying to help others. But when I say repo debt, what I'm talking about, the technical word is a repossession deficiency. That's the actual term that we're talking about. This is really the balance when the car is repoed. Um, sold. So that's going to be a dollar amount. Then they're gonna that amount. There's going to be a final amount. It's going to be your loan balance minus the sale price. Okay. So that's the repossession deficiency. That would be basically what's called the repo deficiency balance. So that's how that number is calculated. So for those of you that see that on your credit report, if you had a car repoed, that balance, which is called repossession deficiency, is what balance is left over after the car is sold at the auction. And that's the repo auction. Okay. So now you know what that number means. So when I say repo debt, that's what I'm talking about. We're talking about the balance from a car loan. Now, how does all this start? Well, it started first. You bought a car with a loan. When you bought that car with a loan, you completed what's called a retail installment contract. Now, that is that loan form that gives you how much you're borrowing, what your payments are going to be, et cetera, et cetera. That's that loan contract. K stands for contract. Okay. So that form, within it, it has what's called a security agreement. Now that agreement makes your car collateral. And all that means is if you don't honor the terms of that installment contract of buying that car, the lender in that retail installment contract can legally take the car within the law, and we'll talk about that, and sell it at an auction to try to satisfy your financial obligation for that car loan. Okay. And I'm going to keep an eye on these comments. Um, okay. Thanks, Neil. Yeah, I see your comment. Okay. I'm going to keep an eye on these comments. So, at any point, like Neil did, let's take any questions. Now, DL, tonight we're talking about repo deletions. So I should say, talk about how to delete medical collections in a future lecture. So be sure, DL, to subscribe to the channel, and you'll get notification when I talk about that. So Neil asked a good question. If a client has gap insurance, does that come into play? Yes, it does. Gap insurance, and let's talk about that. Gap insurance is designed to fill the gap, um, between the insurance coverage. And what that means is your insurance company will, if your car is insured and you have comprehensive coverage that will pay for the damage to your car, well, they're going to pay for the value of the car. They're not going to pay the value of your loan. So when you have auto insurance, that doesn't protect you because when your car is crashed and totaled and things like that, it just protects your car. Now, in a repossession insurance case, um, Gap doesn't really play a role, Neil, in repo, but a lot of times people's car they're basically in a total accident where the car is totaled, And what happens is the car ultimately is repossessed, what's left of it. And of course, they can't really sell it for anything most of the time if it's totaled, but they do have sales sometimes. The gap insurance may play a role in that because it's an accident. But if there's not an accident involved, um, if there's not an accident involved and this is a repossession because of a financial default, I don't believe gap insurance will play a role here. But that's a good question because you do have a lot of situations where there's an accident and the person can't fix the car, won't fix the car, or the car is totaled. And of course, they're not going to continue to pay on a car that's totaled. And when that car is totaled, it's the financial obligation doesn't stop. So if you don't have proper insurance, your insurance company may pay you for your comprehensive, coverage for your loss of your property. But if that car is upside down, meaning you owe more on the car than what it's worth, then you're still going to have a balance. And if you have gap insurance, that will help. The insurance company, that car, may have a low value. They may sell it as a junk piece of car or not, but you do have something to worry about. But that is a repossession. Like if you get in an accident and your car, I mean, you stop paying on your car, insurance doesn't cover all of it. Insurance company will get what's left of the car. They may sell that. That could play a role. So thanks, Neil, for that question. So I'm just sort of walking you through how all this stuff is started, and I'm not gonna get too deep into technical terms, but I'm gonna be sure you have a general understanding of everything, so that you understand how all this came about. So we understand the end, but I want to take you from the beginning to the end. Um, Neil brought up gap insurance. So okay, so you bought the car, you got a loan on it. Okay, that's a very important part of it. You had that loan. You signed a retail installment contract, and the car was collateral. Okay, so let's actually play off of that a little bit more. Now, on that contract, you'll see, interestingly enough, if you hopefully kept that contract, you'll see the seller, which is really technically the lender of that contract, is usually, interestingly enough, the dealership. Okay. And then, of course, the buyer and borrower would be, if we're talking about you buying a car, that would be you. Now, a lot of you understand quickly that that dealership, who is listed as the seller and technically the lender, is not who really loaned you the money. Those contracts are immediately assigned. So remember, K stands for contract. They're assigned, and they're typically assigned to one of those major, auto lenders. All right. So you name it. It's a whole lot of them. And so what you'll see, usually on the first or second page, assignment language, and a signature by an authorized person at the dealership. And usually they already have stamped on there who it's assigned to. So this is very important because sometimes there's some issues with this assignment. I've had cases where the person signing the assignment may not have been an authorized person, but for the most part, you'll see this assignment language on the first page. And this is where the loan contract is assigned to your lender. That's who you end up paying on a, that's who you're going to end up paying on a monthly basis. That's who you'll end up getting, the coupons from, the email saying, we'll be accepting payments for your car. So that's how it happens. All right. And we're going to skip past the gap insurance. So what's next? Well, all is fine. So all is fine for the most part. You use the car, you got your insurance, you got your tag, life is good. All right. Now, what happens? Now, for whatever reason, there's a situation that comes up, and that's called a default. Default is when you basically violate contract terms. So you may miss a payment. Maybe, you can also fail to insure. It's a lot of things, ways you can default, um, et cetera. Um, so after a certain number of missed payments, the lender will, send, notices, regarding the late payments. They'll continue to send late notices. After a certain period of time, they're going to hire a repo company. That repo company is going to, find you, more so try to find the car. Obviously, um, they're assuming the car is going to be with you, so they'll do, different things, skip tracing, etc. Now, what will happen is after that is the repo. Okay, so the repo is when um, the car is taken. An important thing to know about the repo: it must be done, peacefully. It actually is a violation if you breach the keys during the repo. That can violate the law and affect the lender's ability to be able to collect that deficiency. So that's how the repo plays out. And a lot of you uh, may have known that, but we just wanted to sort of outline how that repo plays out. So you buy the car, you get a car loan. That loan is assigned. The car is collateral in that loan because of that security agreement in that loan paperwork. And then that lender that was assigned the contract, they'll service that loan, accept your payments until you stop paying. All right. And when you stop paying, that's a default. They'll give you a little bit of time. They'll send notices and more notices. And then eventually they're going to hire a repo company. They're going to find the car and ultimately repo the car. That's when they actually take the car peacefully. Peacefully just mean without protest. So if you're protesting it and causing a scene, that's actually not peaceful. Now, so that's that. That's the repo process. So now your car is gone. A lot of times when your car is gone, you'll have um, opportunity cure. This happens a lot where you can actually contact your lender, get a reinstatement balance, okay, or and pay that. You can pay that. Usually there'll be some fees, that are additional for them having to repo that they will charge you, like a repo fee, late fees. So I've had some clients who actually were able to recover their car just by doing these things. So if a person, obviously this has to be done pretty quickly. So if your car is repossessed, you do have typically a short period of time that you can contact the lender, try to reinstate that loan. Sometimes people may not be able to fully reinstate it. They may work with you. You may be able to negotiate. Um, you may be able to negotiate some things, but more likely not, because now you're at what's called an inferior bargaining position. because the car is gone. So, and again, if you like, if you're learning here, be sure to utilize the super chat, um, PayPal, Cash App. I want to be able to come back as much as possible and give you this. A lot of you are like, well, where have you been? I haven't seen you in a long time. Well, I actually have hundreds of students that I privately teach weekly. So I've been mostly on there, but I've been thinking I need to get back and get some general content out there for you all so that you can know some things that can help you. And then some of you might want to even join the private teaching I do on a weekly basis. But back to here. After repo, you're going to have a short opportunity. You can actually cure the loan. A lot of people can take advantage of that. Some people can't. Um, just to be complete, some people take advantage of some bankruptcy options. You can see a BK lawyer about that. Sometimes with a repossession, like foreclosure, some bankruptcy lawyers may help people, uh, you know, recover um, their property, and some people utilize bankruptcy for that. I don't practice um, bankruptcy law, but just want to let you know that there are options within that area for people. So you can always consult a bankruptcy lawyer if you're unable to cure. So if you're unable to cure, for example, then you may, if you want to recover and save your car, you may be able to utilize some options under some types of bankruptcy. So just want to put that out there for those that may need it. Now, what happens after the car is repoed and you can't cure it? This happened a while ago. COVID, all kind of things. I mean, there are many things that may cause this: divorce, loss of job, you name it. Many things can cause a repo to happen. When it happens and you don't have the opportunity to cure it, the car is sold and it's gone. Well, what happens? Well, the lender, I'm going to say lender or servicer. Lender, when you think about it, remember in that contract, the lender was the dealership. So that contract is assigned, and sometimes it's assigned to companies that may be a servicer. But lender, servicer, that's basically who accepts payments. Um, uh, they sell the car. Okay. It's going to be at an auction. It's going to be either a private auction or a public auction. There are two types of auctions. Clearly, a private one is not open to the public. Um, and the public one, is open to public. So it's going to be one of two types of auctions. All right. And um, buyer buys the car. All right. And money received from sale by the lender is applied to loan balance. And of course, there's going to be some fees, right? So you're going to have the loan balance. The fees will be those late fees, the repo costs, auction, maybe some fees. They all have to be legal fees, all the fees that were agreed to according to the installment contract. But you can expect, a fee for that repo, a fee for the late fees and things like that. So, but that money received for that car sale at auction is applied to that loan. So let's see what that will look like. Let's say you bought the car. Um, let's do it like this. Uh, bought the car for say $10,000. sold at the auction for, let's say, let's be for real. It's probably going to sell for. Actually, let's go down. It's going to sell maybe for $3,000. All right. Um, and let's just make it simple. We're going to say, there are no, fees. Let's see. Uh, let's see. So fees, let's say $1,000. Okay. So to get that balance, so we want to do so to get what's going to be owed. So that's the loan amount, by the way. The loan amount, let's say 10,000 as well. Okay. So you bought it for you put let's say you put nothing down. You got a full loan. So now you owe, and let's say this. Let's say let's do this. Your balance. Let's go back up. Okay. So obviously you made payments. Your balance at repo was, let's say, $9,000. Okay. So we're doing a little math here. So can anyone tell me what would be the repo debt? How are we going to calculate that? What would be the repo debt, which, as you know, is called a repossession deficiency balance? What would that be? I could post that in the comments. Those of you that are still awake, what would that balance be? Let me pull it down. Um, Remember, the original loan amount is 10,000. The balance at the time of the repo. That's right. Excellent. Excellent. D. Charles, appreciate it. Roderick, that's correct. That's correct. So y'all are good at this math, because very good. We took the fees, added to the repo, the balance at the time of the repo. That gives you $10,000. Sold it for 3. Um, so we got 10K minus 3K. That equals $7,000 repo debt. Okay. So that's correct. So on the credit report, you may have a situation where, credit loan balance after that repo is going to show $7,000. Okay. Now, all right. So we got all the way to here. That's a big debt. And this is not a typical. Okay. A lot of times when these repos happen, the car does not sell for much at auction. Most cars, and some cars more than others, as soon as you buy it, the value of the car just drops. Like Mercedes, you buy cars new, I mean, it could be tens of thousands of dollars depreciation as soon as you leave the lot. So anyway, that credit report will show that loan balance of $7,000. That's what we mean by repo debt. That would be repo debt. Remember, that stands for repossession deficiency balance. I put these terms in quotes because that's the actual term for it. All right. So how to delete that balance? Well, first of all, uh, I like to sort of get your mind right. Know that it can be deleted legally. Okay. Um, Understand that because a lot of people may have a mental block and just thinking that they can't legally delete it, they can't avoid it. Um, bankruptcy is not necessarily necessary. Okay, so understand you don't have to file bankruptcy, but understand, know that it can be deleted. Um, just mentally, you have to get that established. So I want to establish that with you. I'm going to show you how to delete it. Uh, First, you want to, and most of you may be aware of my book, Four Steps to Better Credit. I'm going to, I'm going to utilize some of these steps, um, and you can grab that on Amazon. But it's what I call the real method, and we can apply this today to our repo. The Four Steps to Better Credit really applies to almost everything you're going to deal with on your credit report. If you all are learning something so far, press two. If you're learning something so far, press two. A lot of you here are already very well versed at credit, and that was probably a review for you. But if you learn something new, give me a two here. But the four steps of better credit. This is the four steps of better credit. You want to review, and we're going to apply that because I like making things in steps. We're going to apply that. The first step is you want to review. Review your credit report. Do I need to spell that out? Okay. Review your credit report. Where are we going to review our credit report? Well, I want you to understand the difference between credit report and a credit uh, uh, consumer disclosure. Credit report is from a third party. Okay. It's basically a CRA gives it to a third party, and then you get it. Okay. That's a uh, that's a credit report. A consumer disclosure is from the CRA to the consumer. And the reason I'm bringing this up is because many of you are directed to go to annualcreditreport.com, Equifax.com, Experian.com. Well, when you go to the consumer reporting agency, they're going to give you what's called a consumer disclosure. Um, However, under the FCRA, your rights and how you deal with that disclosure are very, very limited. So, what you want to be sure to do is to get an actual credit report because that is published by the CRA, which stands for Consumer Reporting Agency, to a third party. Okay. So, um, for example, the Fair Isaac Corporation is a third party. An example of where you can get your credit report, myfico.com. Okay. That's an example of how you can actually get your credit report. I'm aware, there's Identity IQ. Can someone tell me some other places where they get their credit report? Yeah, Identity IQ is one. I think that's their website. That's one. What you have, Credit Karma. Okay, those are some examples. Now, I recommend, I do recommend myfico.com for particular reasons because it's going to generate you a FICO score. Okay, someone else gave me another one, Smart Credit. Let's see. Let me let's do that. Let's do it like that. Okay. I do recommend um, my FICO because you can get your FICO score. Some of these others may provide a FICO score. Credit Karma does not, use the FICO score. They have a Vantage score. So, I do like this, but understand that all of these companies and someone named Smart Credit, I think they're spelled like, like that. Smart Credit. Okay. Privacy Guard. Let's see. I think Privacy Guard may be one. I'm gonna have to double check that. And Smart Credit, I believe, is third party. Some of these consumer reporting agencies may have purchased and integrated some of these. Not the ones I've listed, but the ones I've listed here, I think, are definitely third parties. And so when you get this credit report, it's more actionable because if you have to end up lawyering up or if you're damaged by what you see, you can only recover if you're damaged from what's on a credit report. Um, but on a consumer disclosure, you have limited options against the CRA. Okay, so I really recommend you when you reviewing everything, you get yourself a uh, a credit report. Okay, so you do that by getting it from these third parties. All right. Now, uh, in addition to the credit report, you may have what's called dunning letters. These are letters from the servicer or debt collector, um, or even a debt buyer. Okay, you're going to review those letters because those letters are going to have information on how much they're trying to collect from you. All this stuff is going to be used to your advantage. So you want to review. You're in the collections. You're in the collection of documents and information phase because I'm going to show you in just a moment how you can use all this information to actually possibly delete and get out of and eliminate that repossession deficiency debt. Okay. So you want to collect all of this. You want to get a copy of your credit report, those dunning letters that you got. Now, it may not be from the lender. Now, what happens is the debt can be sold. Okay. This may be before or after the repo. You typically will see it, well, you typically will see it after repo. So you have a lender that, will repo the car. They'll sell it. They'll sell the car at an auction. And then there'll be a repo, debt, which we call what? A repossession deficiency balance. And then they'll sell that to a debt buyer. Okay. So Some of you may or may not have seen a situation where another company who's a debt buyer, they'll buy this debt from the lender, and then they are trying to collect it. So they'll produce paperwork saying they bought the debt from the auto lender and ask for payment. Sometimes they'll even show up on a credit report for that balance. And once again, if y'all learn, if y'all getting some value here, be sure to hit that super chat and show some love here so we can keep doing this. And if you have any questions along the way, you can post those questions and I'll be sure to see it. So yeah, so this debt is going to be collected either by the lender if they still have it, or if they sell it to a debt buyer, you may see that debt buyer show up in the credit report with that deficiency balance. And when that happens, you'll see that lender zero out. So those are different forms where you'll find this. So you want to review this. You want to see who's who. You want to figure out who's actually collecting on it. For the most part, many of you will see it as the lender that's typically accepting payments throughout the life of that loan. But there are a select few that will find it elsewhere. Some people, you may even get a lawsuit. You may be sued. So a lot of this process, you may be reviewing a lawsuit where someone is suing trying to get that deficiency balance. So whatever the case may be, you want to review it. So let's go back. So you want to review this by looking at the credit report. That's going to give you that balance. You're going to see that number there. Now, some of you surprisingly may even see that where that number never changes. So that's a big problem, where they're still trying to collect the regular balance after they sold the car. That's a big problem. Look at the dunning letters. That's going to come from the lender. Those letters may also may be called calculation letter. That's what we call a post sale letter. So you also want to look at that. And we're going to talk about right now the importance of that, because that's what you're going to really be able to use to delete that repo. You should have this letter. If you don't, it's a big problem from the lender, but a good situation for you. And like I said, in a limited number of cases, you may have been served a lawsuit, and so that may be how you're learning and reviewing all of this too. Now, here's the best part. A lot of my students, they love this part because we're getting down to the meat of it. But how do you erase that repo debt? Well, first of all, dispute it with the what I call the OC or the DC. The OC stands for original creditor. DC stands for debt collector. So how do you know which one? Who's collecting on the repo debt? Who did the repo? Those are some questions you want to ask. So you want to dispute with one or both of these entities. But to make it simple, we're gonna deal with who's trying to collect this repo debt. Many times it's going to be the same entity or the same company that repoed it. Sometimes not. So let's go through the dispute process. 'Cause, 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 The dispute process with a repo is completely different from disputing anything else because it's going to utilize some laws that you're not typically going to run across when dealing with any other types of debt. So that's why I wanted to start with this repo because it's one of the largest debts. I think the only thing larger would be perhaps student loan, medical debt, and mortgage debt. So we'll do something else. But repo, we'll do those another day. But repo debt is one of the largest debts out there. The dispute process is going to be what we call a direct dispute. Um, I guess I'm going for that. It's a direct dispute process because you're dealing at specifically with who's trying to collect that money from you. All right. And I tell most of my students, think of it like playing cards. When you have a deck of cards, there's some joker cards. You only have a couple of joker cards. So you want to use them wisely. And a lot of people don't realize it in the credit industry that you don't get multiple opportunities to dispute with a consumer reporting agency. So, in many instances, you really want to reserve that for last and utilize some direct dispute methods because the direct dispute methods will, in many times, cure the credit reporting, meaning who you directly dispute with can fix the credit reporting. But if they won't, then you can deal with the CRA, Consumer Reporting Agency. And the Consumer Reporting Agencies, for example, as you know, are Equifax, Experian, and TransUnion. So the dispute process is a direct dispute. You going to attack UCC violations by the original creditor or the debt collector. And so I put OC or DC because it depends on who's collecting it. So remember, the original creditor, technically under the agreement, is not the original creditor because the original creditor, according to the agreement, would be the dealer, according to that document. But usually, the original creditor, we're talking about the signee of that contract. Okay, so it used to be what GMAC. They call it something else now. You have it could be Santander. It can be various people. Now, debt collector would be, for example, a debt buyer. A debt buyer would be an example of a debt collector. So, um, pardon the typo, but you're going to attack the violations. What violations are you going to attack? Well, a repo I talked about earlier. There's some things that have to be complied with, and this is due to UCC law. And I'm going to actually show you the laws, but I'm going to tell you some of the requirements. One, we already talked about it has to be peaceful. So basically, no breach of the peace. And all that means is if someone is protesting, you know, protest, violence, breaking, uh, entering, they can't do that. They can't do any of that. Okay, so it has to be peaceful. Um, most of the, well, I'll say most of the cases I see may be peaceful. Someone grabs the car, even someone is home and lets the repo company take the car peacefully. So most of the time it's peaceful. When it's not peaceful, you'll typically know, don't take my car. You're holding the car. You're backing the car off of the tow truck. You pretty much know that. So most of the methods, like for example, we're going to assume it's peaceful, but I just want to let you know that is a requirement. It has to be a peaceful repossession. The second requirement, there has to be a pre-sale letter. We're going to talk. I'm going to show you what this is about. There has to be a pre-sale letter. It has to be a post-sale letter. Okay. and it has to be um, sold in a reasonably commercial, uh, a reasonable manner. Okay, it has to be a sale, what they call, arm's length. I think I got that backwards, but arm's length transaction. So it can't be, hey, um, Leslie, come over here and buy this car at this private auction for $1. Um, uh, so I can get a big repossession deficiency. You can't do that. It has to be a proper sale. Okay. So for the most part, you're going to find your violation right here when it comes to this pre-sale and post-sale letter. Okay. And I'm going to actually walk you through how the law applies to that. These very simple two things here is going to allow you to delete that this whole deficiency balance. Okay. And I'm going to take you off of that one, and we're going to bring you to a certain area, another area on my screen here. Let me show you the laws that you're going to want to use to deal with this. All right, so let's see. Do we have any questions yet? Let me see if we have any. We don't have any super chats yet. Where are these super chats? Let's see what we got. What we have here. We have any? I ain't got any notice about any super chats yet. How we doing, y'all? All right, let's see. Let's see. Be sure to like it. All right, we got 6 likes. Let's get some more likes. We have 15 watching, so everyone hit like. We're about to get to the real down and dirty information. Let's get some more likes here. We have 15 watching, so hit the like button. Let's go ahead and hit this like button. Let's get at least 10 likes. Appreciate that, D. Charles. Appreciate that. Appreciate it. All right. Thank you. All right, Irene. Yep. I appreciate that. So let's get a couple more likes here, you all, because I'm about to give you all the game. Appreciate you, D. Charles. Yeah, I'd be happy to come on here more, y'all, but let's show a little love here. And let me see how many likes we got. All right, we got 10 likes. So let's move forward. Once again, thank you, D. Charles. And Aaron, I'm about to give you all the game. So let me open this screen up, and I'm gonna make it a little bit bigger for you. Let's do that. See if I can make it bigger. See how that looks. How's it? Oh yeah, very good, very good. So I'm gonna hide the comments. So yeah, keep this. Let's get the super chats up. This information is valuable. Let's support. I meet once a week, Eric, in my credit mastery. We dig real deep into it. So look, so this is the UCC, and this is how you can find it. You can just go to Google UCC Article 9. That's how you find it. UCC Article 9. You click secured transactions, scroll down to part 6, which are the 600s. Okay, that's how you find it. So I'm already on it here. is part 6. So UCC Article 9, part 6. I'll put this in the comment section. Um, this is how you find that. Okay. Um, that's where I'm looking at. That's how you get to it. All right. So let's go through it a little bit. Now, this is going to be not too. I'm gonna make it interesting for you. I'm not going to bore you with all of this. I'm just going to hit certain parts that you need to know. So if you're taking notes, these are the parts that you need to know. Now, a lot of you may be wondering. Thank you for the Cash App. I appreciate it. Let's see who we have here. I appreciate that. This is very appreciate Overton. Thank you. Thank you very much. So I appreciate that. So this is where you want to be, and I'm going to show you about 4 different sections that's going to show you how to delete this repo debt. Now, remember, let's review. I told you about 4 things that have to be done for this repo to be legal. It has to be what? Peaceful. They have to do a pre-sale letter. They have to do a post-sale letter. Okay? And what's the last thing? What's the last thing? What's the last thing we have? Make sure y'all paying attention. Let me see if I can actually show you here. And that's why I said it has to be done in a commercially reasonable manner. I said reasonably commercial, but it's actually a commercially reasonable manner. Okay? So those are the 4 things. And Melody, thank you for the Cash App. Thank you, Melody. Yep, that's right, Aaron. Appreciate y'all paying attention. Reasonable manner. Okay. Um, and let me walk y'all through that. So I'm going to walk y'all through. And the reason I'm doing this is a couple of reasons. And first of all, congratulations for y'all. Y'all about an hour in. We have probably about 30 more minutes to go at most. We'll take some questions shortly, but I'll give you a link where you'll be able to come on and ask questions. But we're about 5 minutes from me giving y'all the full game. The reason I'm showing you this is because what I'm noticing, the reason why I'm here today is there's a lot of misinformation on the internet, and what they'll do is they'll sell you a template, and you get that template and you fill in your information, send it off. It may work, it may not work. And people that have used templates that are garbage out there that have worked, I always remind people that if you take your battery out of your watch, it'll work twice a day as well. So what I want to do is empower you with this specific legal basis of why what I'm telling you will work, so that when you're faced with some other method or some other information, you'll be able to distinguish whether it's garbage or not. Okay, so let's look at this. So this law, peaceful pre-letter post. That's right, Rich is one of my students, and appreciate you, Rich, chiming in. That's right. So y'all are learning a lot tonight. This actually, within this hour, y'all are going to learn more than probably 90% of the general population. So once you hang up with me, you're going to be in a very superior position in dealing with these things for yourself and for others if that's your business. Now, let's go to 611. Okay. 611 is the pre-sale letter. So if I had to tell you what that law was, it would be UCC That's the pre-sale letter law. Okay, that's what that is. All right. Um, it's Article 9, Section 611, but you'll understand once you get to it. But that's the pre-sale letter law. And now let's go over it a little bit, because if we go over it together, you'll never forget it. I hope not. Notification before disposition of collateral. Now, some of these words, I tell my students, every word is very, very important. So this section, notification, is notice, when you give notice. Before is just what it says before. Disposition means sale. We're talking about selling. We're not talking about moving it, but we're talking about selling it, of the collateral. Remember earlier we talked about what the collateral is. That's the car. And so this whole section deals with everything about the notifications before the disposition of the collateral. So before they sell this car, this is what needs to happen. It defines notification date. That's when they, secured party. Secured party is who? Remember that security agreement? That's the lender. The debtor is who? Remember, that's the borrower. The secondary obligor would be who? Like a cosigner. Okay? So y'all are learning some words tonight. So they're just saying notification date. You'll see that. But I'm going to scroll down to what's really important. All right. This is what's very, very important, because the lender or whoever is selling this car has to comply with this section. To comply with subsection B, which is right here, and let's read B. Notification of disposition required. So when anything is required, that means if whoever it's required from doesn't do it, they're violating the law. Okay? So that's what it's saying here. Let's read it. Except as otherwise provided in subsection D, a secured party that disposes of collateral under section 610, and I'll show you what that says, shall. Now let's stop here. When you see the word shall in the laws, that means it's required. There's no if, ands, or buts about it. That means they have to do it. The opposite of the word shall is may. May means they don't have to, but they may. But when you see the word shall, I want you to pay very close attention on what comes after. Shall send. Now, these words that are highlighted in blue, you can click it and it'll give you a definition of what send is. Send is to mail, deliver for transmission, transmit. So it can be an email. It has to be sent. So that's why I gave you all that link, because these words are defined and they're important if they're linked. Shall send to persons specified in C a reasonable, authenticated notification of disposition. Now, these words are a little different. So authenticated, if you click that, that means signed. Okay. Or with the present intent to adopt, accept as a record, with a symbol or process. But authenticated means signed notification of disposition. It has to be reasonable. Okay. So let's go to C. To comply with what we just read, the secured party, who's the lender, shall send an authenticated, which means signed, notification of disposition to the debtor. That's that's the borrower. Any secondary obligor. Who is that? Who would be a secondary obligor? Somebody give me somebody tell me who would be the secondary obligor. Who would be a secondary obligor? Make sure y'all can see this. Is it okay? Good. Okay. So they shall send that notice, authenticated sign, to the debtor. Let's see who we have here. Cosigner. That's right, Shayla, the cosigner. So they shall send that notice to the debtor, any secondary obligor, and if the collateral is other than consumer goods, any other person for which the secured party has received before notification date an authenticated notice of claim. So um, there's a list of other things that may apply if it's other than consumer. What are consumer goods? It means something that a person is using for personal, family, or household purposes. Are we dealing with consumer goods when we're talking about your personal car? Are we dealing with consumer goods when we're talking about your personal car? Yes, we are. So as you see, I sort of blew over that because this is going to be a consumer transaction. So this is very important. Okay. Very important. That has to be sent. All right. So that's going to be something that the lender will many times fail to do. Now, next, I want to tell you what has to be in that notice. Now, let me go back. Let me actually go back to 611. Understand the requirement is that it be sent. So what's going to happen is you're going to be challenging that they did not send it. So you don't want to. So the reason this is so important. All right, Brundy, Melody, thank you so much for that Cash App. If you're getting some value here, definitely hit the Cash App, Venmo, or Super Chat. What's very important here, this is a mistake people may make. They'll say, I never received the pre-sale letter. Okay. But understand the law is they have to send it. So they don't need to prove that you got it. They just need to send it. Now, you remember where it says reasonable here? You see where it says a reasonable authenticate notification? So what does that mean? I know a lot of you saying, like, what is reasonable? Well, it's reasonable to send it to where you are. So they can't send it to an address they know you're not at. Okay. I had a case one time where a company repossessed a car at one place, like the bar had obviously moved. So they repossessed it at the bar's new address, but they sent the notice, the pre-sale notice, to an obvious old address. So I don't think it's reasonable for them to be sending these pre-sale letters to addresses they know are no longer valid, because that doesn't give the borrower the opportunity to know where it's going to be sold, etc. So anyway, understand that the legal requirement is for it to be sent, and it has to be sent reasonably. Obviously, it's unreasonable to send it to the wrong address. And so I wanted to go back and let you understand, because that's where a lot of the issues come up, where it's actually not sent. And what the lender will do is say they sent it, but guess what? They have to prove it. Well, we're going to talk about that in just a second, but I want to get through the elements. Now, section 614 is the legal requirement of what has to be in the pre-sale letter. Very important. Most of you will get the repo deleted because they can't prove they sent it. That's going to be a way most of you are going to get. I would say over half of the cases I see the lender fails to send it. And even if they say they sent it, they can't prove that it was sent. So most of you will achieve a result there. What if they can prove that it was sent? Taisha, thank you for the Cash App. Y'all are just awesome. What if they can prove that it was sent? Then we want to look at whether the content of that notice was proper. Okay. All right. So that's the next thing. Okay. But understand what I just gave y'all so far, 50 to 80% of you or more are going to get the repo deleted because the pre-sale letter was not sent or they can't prove it was sent. Okay. So what you just learned there seems simple, but that alone is what most of you are going to be able to delete that repo debt from that. If you can't, if all of that lines up properly, now you want to look at the content of that notice. Okay. This is where you go to section Article 9, section 614. Okay. 9614. We got a question here, and that's good. Let's get the questions. Do they have to send it certified to be able to prove they sent it? This is a good question, and I'm glad you asked that, Shayla. That is a good question. So, to answer that, let's go back. First of all, I'm going to give you a simple answer before I take you through the law. The answer is no. The answer is no. Now that I've answered it, let's go back and check to see. The law says they shall send. So if we click send, let's see what send means. Send means, in connection with a record or notification, means to deposit in the mail, deliver for transmission, or transmit by any other usual means of communication with postage or cost of transmission provided for, addressed to any address reasonable under the circumstances. Okay. For what we're talking about, this is what we're talking about. We're not really talking about records to cause a record notification to be received within the time that it would have been received if properly sent under A. So we focus on this. Now, to deposit in the mail, postage paid, reasonable under circumstance. So from what you see here, do you think it needs to be certified mail, overnight mail, or anything? Any comments from what you see there on how to send it? Okay. So according to what you see here, it does not have to be by certified mail. It can be regular mail, but you have to put a stamp on it. It has to be, you can't just deposit in the mail. You see, with postage or costs paid for. So, it just has to be sent. So correct. No, it doesn't have to be certified mail. Now, and really, technically, you can email it, fax, but it has to be reasonable. You have to email it to the right email. You have to fax it to the right number. But it has to be reasonable. They had and all right. So what Rich is saying, it has to be proof, and um, and so let's talk about that, because again, I'm telling you, over half of you are going to succeed in getting this deleted because they can't prove it was sent. Okay. So let me go back to the law here. So we're going to go back. So they have to send it. Now, if you're disputing that they didn't send it, what are they going to do? Oh, we sent it. Well, if you're challenging it, then they're going to have to prove it. The lender saying they sent it is not proof. It's not definitive proof that it was sent. So what you can so how are they going to prove, excuse me, that it was sent? Can someone tell me some ways they could prove it was sent? Because the law says they have to send it. Them saying that they sent it, if you have them saying that they sent it and you saying you didn't receive it, now you have it's their word against yours. So that's completely even. All right. So one way they could prove that they sent it is they sent it certified mail. Okay. Now, do they have to send it certified mail? We just established the answer to that is no. Okay. But if we're challenging it, then it has to be proven. And let me go down for a little bit and show you. The law talks about this. And I'm just going to, I don't mean to jump around too much. And so the law provides in 625, if the secured party doesn't do what they're supposed to do under the law, they can be restrained from collecting anything, enforcing anything. And that's on 625. So this is why we're really digging deep into it, because if they don't do something proper, they can't. The lender can't collect. If you you can bring an action against the lender if they can't prove it, you can bring an action against them. And this is something the law says in Section 9, Article 9, Section 626. A secured party need not prove compliance with the provisions of this part relating to collection, enforcement, disposition, or acceptance unless the debtor or secondary obligor places the secured party's compliance in issue. What does that mean? I want to come to this. What does that mean? Okay, Cedric, I like that. That means if you don't make an issue of any of this, everything is going to be assumed to be in compliance. So without you knowing that these issues may exist and bringing them up, the assumption is everything was done correctly. So this is why we're taking our time understanding these requirements. All right, so next, so back to certified mail. And Cedric, one of my students as well, brought up affidavit. So let's go back to certified mail. What the lender will do is say, we sent it and we can prove it because look, here is the certified mail information. Okay. Now, if this happens to you, which it happens all the time, what do you do? If they send you, if you challenge that they sent it and they say, and you say, prove it, and they come back and say, we sent it certified mail. So So I don't know what you're talking about. What can you do? Are you done with that requirement? What do you do? Anybody? Well, you take that certified mail. Well, first of all, if they say you sent certified mail, then you want to get the tracking number. Yep, that's right. You're not done. That's right. You want to check the certified number online. That's what you want to do. That's what you want to do, okay? How do you do that? Of course, go to UPS, well, USPS. What is it? Is it .com? Yeah, USPS.com. You go here, you take that tracking number. Oops, let's back it up. You take that tracking number and put it right here and check it. All right, you put it and you check it. Now, if you check it and it comes back like this, what have they proven? That's right. Ask for the tracking. That's right, Shayla, Taisha, Iron. Ask for the tracking. If you put that tracking number in and it comes back like this, what have they proven? Have they proven that they sent it? If it comes back like this? Have they proved they sent it when it comes back like that? Okay. No, they haven't. So when it comes back like this, you can say that there's no evidence by this tracking number that anything was ever sent. Okay. Do you think this happens? Do you think this happens? Would they say they sent something certified mail when in fact they didn't? Happens all the time. Happens all the time. It happens all the time. So they'll say they sent it because you can go to the post office and get some of the certified envelope. I'm sorry, the little sheets that you attach to the envelope. And oh, you can say you sent it unless it has a stamp on it. Anyway, it will show up here. Now, I've had cases where the lender will say, well, we sent it, and the U.S. Postal Service doesn't keep tracking information beyond 2 years online. Okay, whose problem is that? Is that our problem or is that their problem? That's their problem. So what you'll find, and a lot of my students, I have cases that I've gone over in class, lenders will take that little certified paper and pretend they sent it when they didn't. They'll even go so far as to take the little strip of an unsent letter, use the letter they have on file that may have been never sent, and scan it with that as if they sent it. It's ridiculous. But if you search that number and it comes up like this, that proves nothing. So you see how easily they could fail at proving that they sent it. So great question, Shayla, I believe, brought it up. So that's that. If you put the number in and it shows something was sent and it went to, you live in Denver and you see that it was delivered in Los Angeles, is that reasonable? No. So this actually, like I said, this particular step is probably one of the best ways to defeat that deficiency, because if they didn't do that, they can't claim a deficiency balance. They're owed zero. They can't claim a deficiency balance if they didn't do this step before they sold the car. So you're going to ask them to prove it. Now, I have all the templates for you on how to get this, how to achieve this. So I'll show you how to get that at the end here shortly. But yeah, if that doesn't come up, nothing is proven. If it comes up, be sure it comes up to your city. If you live in Denver and it says that thing was delivered in Los Angeles on a certain date and you never lived there, that's not good. Now, if you live in LA the whole time you had the car and it was repoed there, okay, and you just moved last week to Denver, I'm sorry, if it was sent to LA and you had the car, it was repoed there, and you just moved just recently to Denver, well, then they may have proved that it actually went to your proper address at the time. Okay. This is obviously dealing with the time it was after it was repoed, before it was sold. So keep that in mind as far as if something comes up, where the letter went to. Obviously, if it says status not available, then they've proved absolutely nothing. You're actually in a great position to getting that repossession nullified. Okay. So great question. We're going to go back now to, I'm sorry. Let's talk about another way. What's another way they can prove that it was sent? Cedric said affidavit. That's absolutely correct. So remember, it doesn't have to be certified. What if they say they sent it regular mail? How are they going to prove that they sent it by regular mail? Well, Cedric just gave you the answer. Well, you sent it regular mail? Well, give me a sworn affidavit from the person who mailed it. Okay. How's that? Great. So Melody has the file already. Good job. So you have this information. Great job, Melody. So if they sent it regular mail, well, first of all, they'll come back and say, you asked for, well, you say you sent it. Well, let me see the return receipt. Oh, we don't have to send a return receipt. That you're absolutely correct. Well, give me a sworn affidavit of the person who mailed it then, because you telling me you mailed it is not any definitive proof. You could be lying, obviously. Now, sworn affidavit is sworn under penalty of perjury. So whoever mailed it, give me a sworn statement to say they mailed it. Oh, they don't work here anymore. Whose problem is that? It's not your problem. That's their problem. That's something they're going to have to prove. So those are the main ways that you can certainly hold them to their obligation to have sent it. They have to prove it. Once again, if you're getting good information here, be sure to hit the that super chat, Cash App, PayPal, Venmo, so we can keep this thing going. Because I can show you how to delete a whole lot of stuff. So tonight we're doing repo. So by some magical reason, they're able to prove that they sent the pre-sale letter. What do we do next? Let's look at the content. Let's look at the letter. Let's look at the content. So Article 9 of the UCC, Section 614, gives us what needs to be in that letter. It needs to be the information specified in 613. Okay. So all this information here needs to be in there. A description of any liability for the deficiency of the person to which it's sent. A telephone number from which the amount that must be paid to redeem the collateral under 623 is available. Remember, we talked about redeeming it, reinstating it. So it needs to be a telephone number or mailing address. Remember this word or, when you see or, it can be one or the other. It doesn't have to be both. So they can give you a telephone number or a mailing address from which additional information concerning the disposition, which means sale, and the obligation secured is available. A particular phrasing of the notification is not required. So it doesn't have to be phrased perfectly in order like we're reading now, but long as everything is there. Again, this is section 614. The following form of notification, when completed, provides sufficient information. So this below are some examples of a pre-sale letter that would be sufficient. Okay, this is just an example. But remember, if we want to know exactly what has to be there, we just look at this list. And then again, you can click on 613 and it'll tell you, what that is. But here below is an example of what would be sufficient in a pre-sale letter. And then we have one more thing to cover, and then we're done. We're going to open up some questions. It needs the name and address of secured party, the date, notice of our plan to sell the car, the property, name and address of any obligor who is also a debtor. Remember, that would be the buyer and any co-signers. The identification of the transaction. We have your car because you broke our promises in our agreement. Now, this is what I want you to pay attention to. There are two types of sales, a public sale and a private sale. So where it says for public disposition, that's a public sale. These are the things that would need to be in that public sale notice. If it's a private sale, these are the things that need to be in the private sale notice. You see the difference? It's very different. Let's look at it. If it's a public sale, they can say, we'll sell your car at public sale. A sale would include a lease or license. The sale will be held on this date, at this time, at this place. You may attend the sale and bring bidders, okay? So that's something that would be sufficient for a public sale. If it's a private sale, this is something that would be legally sufficient for the private sale. We will sell your car at private sale sometime after a date. They don't actually have to give you a date specific for private sales. They just have to give you a date after which it will be sold. So it's a big difference. So you have to pay attention to that. A sale could include a lease or license. The money that we get will reduce the amount you owe. If we get less money than you owe, you'll still owe the difference. Okay. So this is the language. It keeps going. It keeps going all the way down. This is the end. So all of this, I'll let y'all read that later. I'll give you the link here. Remember, let's get the likes up. Let's also do the super chats, Cash App. Much appreciated. All right. Let's keep it going. Let me take down the affidavit. All right. So that's the content that needs to be in that letter. What if the notice doesn't have the proper content? And then some other things, a notification in the form of paragraph 3 is sufficient, even if additional information appears at the form. So what it means is, if it has what we just read here plus more, that's fine. A notification in the form of paragraph 3 is sufficient, even if it includes errors. So if it has a little error, typo here and there, that's fine, unless it's misleading. If a notification under the section is not in the form of paragraph 3, law other than the article determines the effect of including information not required. So if it's not just like you see there, we just have to go back to the law and make sure it has everything that's required. If that makes sense to you, just press 1. Press 1 if what I just went over makes sense. This is the content of that pre-sale letter. Let me know if that makes sense. Press 1 if that was some information that makes sense to you. Okay. Now, press 1 if that makes sense to you. All right, very good, very good. So we're going to move on to the last item of information we're going to do tonight, and then we're going to take a few questions. Now, UCC Article 9, Section 616 talks about the post-sale letter. The post-sale letter. Thanks, Rhonda, Shayla, Garrett, Melody. Thank you for paying attention. UCC Article 9, Section 616 talks about the post-sale letter. Now, this is called explanation of calculation of surplus or deficiency. Now, are we going to get a surplus? No. Okay. But if we did, this section would govern how it's treated. So you're most likely going to be dealing with a deficiency. But if there's a surplus, this law, this section deals with that as well. But anyway, explanation, everything is defined. And I encourage you all to read this. Explanation means a writing that states the amount of the surplus or deficiency in this case, provides an explanation in accordance with subsection C on how the secured party calculated it, states, if applicable, the future debits, credits, charges, including additional credit service, etc. And, okay, so this is very important. When you have a list here, if you see the word and, I want you to stop, look at what's above and below, because that means they must comply with all of these things. So A through D has to be part of the explanation. And provides a telephone number or, remember the word or, telephone number or mailing address from which additional information concerning the transaction is available. Now, request means a record authenticated which is signed by a debtor or consumer obligor. We're going to talk about that. Requesting that the recipient provide an explanation and sent after disposition of collateral. This is going to be very important. This is going to be a wild card you can use as well. This is the meat of it. In a consumer goods transaction, like your personal car, in which the debtor, which can be you or some other consumer, is entitled to surplus, which is not going to be the case here, or a consumer obligor, same thing as a debtor, is liable for a deficiency under 915. That's what we're talking about. The secured party shall. Who is the secured party? Someone write down, who is the secured party that they're talking about here? It says the secured party shall. Who are they talking about right there? Who are they talking about when they say secured party? Can someone tell me that? Who are they talking about? No, it's not the buyer. It's not the buyer. I'd like to quiz y'all on the way, make sure we're on the same page. It says, in a consumer goods transaction in which the consumer obligor is liable for a deficiency, the secured party shall. So somebody better do these things we're about to name. Who is the secured party? Someone tell me. Y'all are doing good, so let's keep it up. Y'all are doing real good. Who is the secured party that this law is talking about? The lender. Yes, 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 yes. Yes, yes, yes. The lender. The lender, the lender. Yes, yes, Iron. Yes, the lender. Melody. Yep. D. Charles. Yes, yes, yes. The lender is not the original owner or co-signer. No, that's not the secured party. That would be the debtor or the consumer obligor. So very good. The lender, that's the secured party. We have a question. So should the first dispute letter to the lender be us asking for confirmation that the pre and post sale letters were sent? Yes, sort of. But I will give you a clue. You don't want to ask for confirmation because they'll confirm it for you. The template that I'm going to provide for you, you take a position. You don't really ask. I mean, you ask, but you sort of telling them they didn't. You know they didn't do it, and they're going to have to prove otherwise. Can a consumer be sued for a deficiency balance if it's still within the debt's statute? Yes. Oh, yes. Absolutely. Oh, yeah. They'll sue you. So very good. So let's finish this, and we'll open up for questions. The secured party, which is the lender or the company that repo that's owed the money, shall And this is a list of two things, so it's pretty good. Send, and okay, we know about send, an explanation. We remember explanation defined up here. So if you're not noticing it yet, every word is very important. Shall send an explanation to the debtor or consumer obligor. Somebody tell me, who is the debtor or consumer obligor? Who is that in this transaction? Who is that? Who is the debtor or consumer obligor? All right. Who is that? Who is the debtor or consumer obligor? And don't forget the super chats, the cash apps, all that. Who is the consumer? Yes, yes, the buyer, the borrower, the buyer, same thing. Yes, 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 yes. So they shall send an explanation to that buyer after the disposition. And remember, and is very important, y'all. This. Listen very carefully. This is the money maker too. That's right. That's right. No, it's not the lender. It's the consumer. Okay. Thank you, Jacqueline Ortega. Aaron, that's right. That would be you if that's you the borrower. Okay. Okay. So they shall send an explanation to that borrower as applicable after the disposition, and very important, y'all. I'm gonna read this real slow. This is gonna make y'all a lot of money or help you eliminate a lot of debt. Before or when the secured party accounts to the debtor and pays any surplus, or first makes written demand on the consumer obligor after the disposition for payment of the deficiency. Okay? Let me just tell you what that means. Thanks, Warren. They have to send this explanation of how they calculate the deficiency to the borrower before they start collecting, or at the same time they send a letter demanding payment. Okay? This is major. That's right, Jacqueline. You figure out or is a very big word. Or is a big word. Yeah, that's right. It's very important we see those ors. So so before or when is the key. So again, we're not worried about surplus. If you if you have a repo and get money back, let me know. But before or when they make demand for their payment, they have to send this explanation. So if you get a demand for payment without an explanation, is that a violation of the UCC? Yes or no? If they repo the car, did everything correct up until the sale, after the sale, they send a letter saying, hey, how much we said before? You owe us $7,000. Where's send payment? Before they send the explanation, is that a violation of the UCC? Yes or no? Yes or no? Yes or no? Is that a violation of the UCC? They sold the car. Yes, it is. That's a violation. That violation alone, if they demand payment of that deficiency before they send you explanation of how they got to it, That, you're right, Shayla, Melody, Rich, Reginald, Rhonda, you're correct. That's a violation, and they can't. They violated. It only takes one violation. So if they do that, it's over for them as far as trying to be able to collect that deficiency. They can't. They cannot at that point. All right. So understand that. And so this and works different ways. So let's go back because it's been a while. The secured party shall send an explanation to the debtor after the disposition. What's that say? Within 14 days after receipt of a request. What's a request? Define it right here. Okay. I'm gonna get a link for y'all to join in a second. Y'all, that is major. Let me tell you what that means. Imagine they never send a demand. So check this out. The lender sold the car and never demanded payment on it. Okay. I'm gonna put a link. I'm gonna put a link up so y'all can join in. Let's see. All right. So this is a link. You can use this link if you want to come on. You can use that link. I think y'all should be able to see that. You can use that link if you want to come on, ask a question or chime in. This is very major. So the lender sold the car but never sent you a demand for that deficiency, but it's showing up on your credit report, and you want to learn how to get it off. You saw my lecture here. But they did everything right up until this point, but they never sent you a demand for that payment. Now, there's an argument to be made when they put it in your credit report. It's sort of a demand, it's collection, but we're not going to go there just yet. What can you do to trigger this law to work in your favor? And if you want to join in on discussion, just click that link and I'll bring you in. What can you do to trigger that? And like I said, you can use the link if you want to come on. What can you do to trigger this? They never sent a demand for payment, but you want to use this law. You're trying to delete this debt. What can you do to trigger this section of the law? What this means is if you send in a request, which is up here, a signed request asking for an explanation of that deficiency, they shall send you the explanation within 14 days of receipt. If they don't send you the explanation within 14 days of receipt, what happens? What's the result? What's the result if they don't send that explanation within 14 days of you asking for it? You know, if they haven't already. What's the result? Violation. Good job, Citrine Credit. Good job. Violation. Violation. You got to delete it. So, violation. You request that document. You request that explanation on how they calculate a deficiency, and they don't send it to you within 14 days of receipt. Rich is telling you that's a violation of the UCC. They're going to have to delete it. You don't owe them anything. They violated this section of the UCC. Therefore, they can't collect. What do we have here? That's a violation admission by. That's a violation. It's not an admission, but they violated you. They violated you. They didn't send that explanation back within 14 days. So, given that if they don't send it within 14 days, after what? Receipt. How you think you better send that request? What's the best way to send that request? Someone tell me, what's the best way to send that request? If they have 14 days after receipt of your request to send it and they don't, what's the best way? Yes. You better send that thing certified so you can keep track. That's right, Shayla. Um, so Citrine Credit asks, can this be the first letter sent? So this is how I deal with cans. It can, yeah, it can. I mean, it can. I don't recommend it, but it can. Um, you know, it can. Um, I don't think it's time for affidavit. But if you just now seeing this and you can't prove, you forgot, you didn't know, you should have sent it certified, you sent a request. Yeah, you can use the affidavit to swear when you sent it. But that's right, Jacqueline. Certified mail, Shayla. Yep. Um, Now, Rich is saying, so some of you say like you've been through, say like you already had the gumption to do this and ask, how did y'all get this amount? That is a request, and you didn't send it certified. You didn't really get to this lecture soon enough. If you have to sue on it because they responded or never responded, if they responded late or never responded, you can, by affidavit, swear that you sent it at a certain time. But again, the proof is when they receive it. So it's not when you sent it; it's when they sent it. So when they received it. So um, now that you know better, we have to do it this way because it's the best way because it's about when they received it. Now, if you sent it, it is assumed within 3 days the mail process will get it to them. But um, finally, in the case of a consumer obligor who is liable for deficiency within 14 days after receipt of such request, send the consumer obligor a record uh, waiving. Okay. So basically, the lender can send a document saying, hey, don't, we waive it. We waive the deficiency. They can do that. So 14 days. So good question. So 14 days are weekends excluded. It's 14 straight days. So it's 14 days, and that's a good question. So you don't see this highlighted. So the days are counted just regular days every day. I've never seen any indication that the days are counted differently than just true calendar days. So good question. I would say just calendar days. Again, I put the link. The link is in the chat. Those of you that want to come on and ask questions, don't be shy. I'll take about 10 more minutes or so answer any questions. But small number of you, I say the biggest percentage will get the deletion and eliminate that deficiency debt due to violations of the pre-sale letter not being sent or proven sent by the lender. Most people have success there. Outside of that, a lot of success is had in the post-sale obligation explanation not being sent properly before they try to collect on that balance, or they don't provide that explanation within 14 days of request. All right. So that's how that works. Uh, um, there's a link in there. You can come on and ask a question. Um, go ahead and ask your question. So, um, going to questions. Let's bring the questions up. Got one question here. All right. What's the process of your car getting repoed, but they still haven't sent any documents at all? So, well, you could be, well, the real question is, has it sold yet? So, if you're trying to recover that car, you can contact that lender and inquire about whether it is available or if it's been sold yet. I recommend you record that call, because what if they say, "Oh, we sold it, um, a long time ago," or whatever. You want to be able to document that, because remember, if you haven't gotten anything, um, there's a possibility that it may not have been sold. If it has been sold and you're seeing some changes on your credit report, you want to be able to document that. So if you haven't gotten anything, um, I would recommend contacting the lender and say, "Hey, where's my car? How can I get my car back?" Depending on what you're trying to do. Let's see. We have a question here with Marcus. Hi, Marcus. Marcus, do you have a question?
Hello?
Yes. How you doing?
Hey, how you doing? I'm sorry, I typed it in, and I was switching the phones to make sure I was doing it right. I typed the question in. That was
Oh,
all.
okay. So I just gave the answer. You heard that?
No, I was switching phones because I was making sure I was doing it right. What?
Oh, okay. So if the car's been repoed but haven't gotten any documents, well, it's a possibility that it may not have been sold yet. So if you're trying to recover the car, you can always contact the lender and say, "Hey, did you repo my car? All right. Well, how can I redeem it? How can I recover it?" You maybe have some reinstatement rights, or they may say, "Oh, we sold that back in July." So um, you can do that. Um, like I said in the beginning, you want to review the credit report.
Mm.
Has the loan balance changed to where it looks like they've adjusted it to show a deficiency? If that's the case, you can jump to requesting the well, if it's sold. Remember, if it's sold and you
Hmm.
didn't get a pre-sale letter, then what? There's a violation already.
Right.
So you can take full advantage of that. That's why I say you want to record that call, because if they say
Okay.
they sold it and you didn't get a pre-sale letter, well, you were violated right there. So you owe zero deficiency. And if they try to collect a deficiency, that's improper and a violation.
Okay. Yeah, because I was in a dispute process with them, and for a while, and they still haven't. So I think
Hmm.
they took the car probably like a month ago, or like 6 weeks, and
Hmm.
um um I had got a cease and desist letter and everything sent to them, and I still, and they still came and took the car. Um, so we, like I said, we was going through that process. So I'm gonna just call, like you said, because it's still on credit report. It still isn't even showing repoed or anything.
Hmm.
So
Okay. All right. Well, thanks for that question. I appreciate it. All right. So I put a link down here. I'll put it in the chat. This is where you can actually get, you can enroll in my repo deletion course that will give you um, all the templates that you would need to go through this whole process. It even gives you some sample settlement agreements, litigation if you have to sue, all the applicable laws and things. This is the repo deletion course. So let's see. The next question I just joined. Will I be able to watch this again after it's finished? I don't know. This is I'm gonna take a look here and see if I gave away too many industry secrets. This may go away um, because we don't want to educate our lenders too much. Um, so you may want to get the course or schedule a consultation. But it's very likely this may be up maybe overnight or over the weekend, and may come down because again we don't want these are a lot of techniques, and we want to be able to have them as consumers. We don't want to necessarily get the competition, which is the lenders, hip to us being hip to their game. So we'll see. What section of the law is this? Which part? This is all, we're talking Article 9, UCC Article 9, Section 6 in the 600s. So you would type in UCC 9 and go down to the 600s. This is where all this is. I also pasted some links in here. Again, if this information was helpful, I want y'all to press 1 and hit that super chat or cash app so we can do some more of these. Centurion Credit. The link is in the chat. What if they don't send the repossession documents you request initially after 14 days? Great. You jump for joy because you've been violated, and you can immediately reap the benefit of that and make sure that they stop collecting their deficiency. Marlowe's Rentals.
No, that I accidentally logged out and logged back.
All right. All right. Let's see. Next question. Take a couple more questions. Anyone else wants to jump and ask a question, they may. I think that's it. So again, we're gonna put this back. So the repo deletion course. Here's the bit.ly link. Go to that. It'll also be in the description. It's going to give you all the templates that you need to go through this entire process. So you're not fumbling through what to ask for, how to ask for it. It already has the proper responses because obviously they're going to come back and say they sent the letter. You're going to have a rebuttal. All the letters you need to do your rebuttals are included. So go ahead and grab that. Also, some of you, if you need a one-on-one consultation, there's a link in the description of the video. You'll be able to do that. Some of you want to join me on my weekly credit mastery lectures. That's called my credit mastery training. You can certainly join that. If you join that, you actually will have access to all this information. So depending on what level you want to come in, if you want to just get this particular repo course, you may, but if you want to get the credit mastery, we're going to talk, the credit mastery covers all of these subjects. So let's see here. All right. Do we have anyone else? All right. So if y'all enjoyed this information, it was useful, let's hit the Cash App. Be sure to subscribe to the channel. There's also a PayPal information there that you can use. And I'll take a couple more questions and we'll be out. Is it okay for deficiency balance to grow due to interest? That's a good question. It may be able to collect legal interest. That may depend state by state and depends on the contract. So that's something that may vary. So on a case-by-case basis, might be able to figure that out depending on where the person is and what the contract said as far as deficiencies. So the law can change state to state on whether that's collectible. Certainly, if they sue on it, they can get the legal interest rate, but Outside of that, that may be governed by the contract, that retail installment agreement. All right. So if y'all found the information useful, press 1 as we get ready to head on out of here. And if you're looking at this video after the fact, once again, you have the Cash App there. Go ahead and drop that Cash App, Venmo, and other things. And we'll see you soon. All right. I'll see y'all later. Have a good night.